watching BloombergQuint. The Cases That India Forgot is Chintan Chandrachud's new book. Now, Chintan is a lawyer born into a family of judges, and might I say, it's an excellent book because it brings alive the law, the understanding and operationalization of the law without once being technical, pedantic or boring. The stories capture the important legal or constitutional principle, yes they do, but also the social and political context of their times. And while the author is gentle in his assessment of the court's weaknesses and failures, he is also resolute in showing how India's judiciary has often lived behind the curve of fundamental rights. Chintan Chandrachud, welcome to BloombergQuint, and thank you for talking to us on your wonderful new book, The Cases That India Forgot.
Thanks for having me.
I'm going to start by what you have outlined in your preface as two important things, if I may say so, that underlie your book and, you know, how the dots in your book are connected, so to speak, right? I think the first point that you've made is that courts often have abdicated the role of protecting fundamental rights. And to that effect, you have said, and I quote from the book, that, you know, there is a large body of work that extols the role of our constitutional courts in safeguarding us from the indiscretions and misadventures of Parliament and the government. This narrative is only partially true and is often misleading. On several occasions, the courts have remained silent and failed to prevent these misadventures. On still other occasions, the courts have created, catalyzed, or contributed to these misadventures. Why have you focused on this in your preface, and why do you think the courts have failed us?
I think this is a particularly important point to make in the times that we live today. I think there's a general view that the protection of rights is within the exclusive preserve of the courts. In other words, it's left neither to the citizens, nor to the parliamentary process, nor to the public at large to protect rights. And that's a matter that should be left first and last to the courts. I think that's a view that we need to rethink. And the reason for that is that courts don't always or don't necessarily protect rights. And my book includes several examples in which the courts have failed to do so, where the courts have abdicated their responsibility or avoided their responsibility to protect rights, but where other institutions have stepped in and done so. And just to give you an example, one of the cases that I discuss in the book is the Kartar Singh case. And this is a case where TADA, which is an anti-terrorism statute from the 1980s, is challenged. And what happens in that case is that the court takes a long time to hear the case, about 9 years to hear the case, and following that period actually upholds the legislation. And it's in fact the public consensus that results in the legislation not being extended shortly after the court's judgment. So what I say in that case is, it's not because of, but in spite of the court's judgment that rights are protected.
In your study of not just the cases that you have articulated or profiled in the book, but you know, in your long study of the law, why do you think the courts have so frequently been behind the curve, whether it is in as standout occasions as the emergency or in individual other such legislative situations, such as, for instance, the TADA or other cases?
I think the simple answer probably is that it's easier. It's institutionally easier for the court to be behind the curve. And the reason for that is when the court is either in step with public opinion or is behind public opinion, its decisions are easier to implement because it's decisions that the majority agrees with. On the other hand, if the court goes further than that, if the court takes decisions which are ahead of the curve, which are not necessarily in step with but are leading public opinion, those decisions can in fact be harder to implement. So in some sense, it's the convenient path to take, but not necessarily always the right path.
But what distinguishes then our judiciary from our politicians?
Well, our judiciary is inherently meant to be counter-majoritarian.
But yet it isn't. When it comes to upholding rights, let's say in the case of an emergency-like situation or otherwise, it never has proven to be, or it has very infrequently proven to be counter-majoritarian. So what distinguishes today our judiciary from our politicians if the judiciary prefers to either stay in step of majority opinion or just a step behind, but never actually take the lead?
So that's one of the concerns which I articulate in the book. I mean, I think it's fair to say that there are some areas where the court does lead public opinion from time to time. So free speech is one of those where you might say the court is fairly progressive in its decision-making processes.
Okay.
But there are other areas where the court is either in step with or behind. And let me give you a couple of examples. National security legislation is one of those classic examples where you might say the court tracks public opinion or is behind public opinion. And if you were to look at national security cases over the decades, if you look at POTA, AFSPA, TADA, any of the statutes on national security that have been enacted, the court's decision has certainly been one that is consistent with the majority view, if you like. That's one set of examples. You can also use another set of examples, cases on gender, cases on personal rights, if you like. And there was an opportunity for the court in 2013, and I'm talking about the Section 377 case, to at that stage you might well say lead public opinion. The court failed to grasp that opportunity. And 5 years later, the court did in fact overturn its previous decision and strike down or read down Section 377. Now what happens in this 5 years? You might well say that what happened was that public opinion itself changed. And therefore the court was now acting in step with public opinion.
Can I interrupt you? But in
Yes.
2013,
Yes.
the Delhi High Court was ahead.
Yes.
And it was the Supreme Court that actually fell behind, wasn't it?
Yes, that's absolutely right.
So I'm trying, I know we look at the judiciary, especially the senior
Yeah.
judiciary, which is the High Court and
Yeah.
the Supreme Court, as one sort of mass whole,
Yeah.
right? But you know, the standouts have been not judges that have not respected fundamental rights, but those that have actually stood up. They have been the few and far between, whether it's an H.R. Khanna from the times of the emergency or an A.P. Shah from, from 2013 or from the Delhi High Court. The broad bulk of Supreme Court senior judiciary or High Court senior judiciary seems to be behind the times. So, I mean, this is a thought that I've often grappled with, saying, why is it that the one body built constitutionally to protect us, has so often failed to do so, whereas in the design of every other institution that makes up our democracy, that failure was sort of weaved in, that failure was anticipated, right? The court was supposed to be the bulwark that sort of protected us from all of this, and it just hasn't worked out that way.
It's interesting you use that example, because my book also includes several cases where the High Court judgment has been more progressive
Than the Supreme
Court judgment. And the Supreme Court has in fact gone ahead and restrained the High Court, if you like, and changed the High Court's view. It's hard to know why that's the case. We have so many examples of this. It's hard to know why that's the case. But one reason might be that the Supreme Court is somewhat more conservative because it's conscious that it's the last court of appeal. I mean, this is very much a function of our own appellate structure, where the expectation in all significant cases is that an important matter at the High Court will almost certainly be appealed to the Supreme Court and will be decided by the Supreme Court. So perhaps where the High Court can gain some comfort is from the fact that it is not the final opportunity, it's not the last throw of the die, whereas the Supreme Court is. So that might be part of the explanation. I don't think that's a good enough explanation, but that might be a rationalization.
Okay, fair enough.
Yeah.
One of the other things, Chintan, a lot of people understand the Supreme Court's supremacy through the saying that, the Supreme Court is not right because it's final because it's right. And you've gone on to, in your preface, to make the other point that this book seeks to dispel the myth that courts have the final word on all the questions that arise for their determination. Explain that to me and tell me why you believe they don't have the final word, and why we must understand that very clearly, because in this country today, almost every time we're let down by our politicians, we look towards the courts for rescue, and we are so often disappointed.
Sure. So the reason I say this in the book is that I think the broader public understanding of the legal system is quite linear, in that the legislature enacts a law, it's then up to the government to implement policy and to implement the law, and it's the court that makes the final decision about the constitutionality and the legality of both the law as well as the government's implementation of the law.
Right.
Now, I think viewing the legal system in this linear way is far too simplistic. And in each of the cases that I've analyzed in this book, what you'd notice is there's in fact a iterative process that takes place between all institutions, between Parliament, the government and the courts, where the court's decision is merely part of the process rather than a culmination of the process. So you have several cases where following the court's decision, the government takes a further decision, and that decision can involve a number of things. It can be a constitutional amendment to overturn the court's decision. It can be a number of steps that the government decides to take in order to sidestep compliance with the court's decision. So what you see very often is formal compliance on paper without complying with the judgment in spirit. It can also be a review petition. Remember, a review petition is something that the government itself, it's a step initiated by the government in order to seek to overturn the court's decision. And so I think it's rather simplistic to say that when the court decides a matter, that matter is final. As a matter of practice, that's simply not how things turn out.
Okay, fine. I can't possibly discuss all the stories in your book for two reasons. One, we'd be short of time, and second, I don't want to give away all of it to all the readers.
Sure.
But I have picked a couple which I thought try and make some large important points, especially in this day and age. I'm going to start with the very first story on Keshav Singh, a case which is about the balance of power between what you call two co-equal constitutional institutions, which is the Parliament, or in this case the Assembly, and the judiciary, or in this case both the High Court and the Supreme Court. Now, at the time, the Supreme Court verdict in the Keshav Singh case went in favor of the judiciary, right? If the same were to play out today, how do you see this going down?
So if the same were to play out today, I would venture to say that the court would once again protect its own authority. The one thing that the court historically has been good at doing is to protect its own authority and its own domain. And so a good example of this is that the basic structure doctrine has seldom been used. Now the basic structure doctrine, just by way of explanation, enables the court to strike down constitutional amendments that are inconsistent or that abrogate the basic structure of the Constitution. This is a radical power that's used rarely, in exceptional circumstances. Most of those exceptional circumstances involve situations where the court is protecting its own domain. And so the most commonly struck down amendment is what we as lawyers call an ouster clause, which is Parliament saying that the courts don't have the authority to review or to test a particular piece of legislation or a particular statute for compliance with fundamental rights or other things. And the court has consistently struck that down. If you want a more recent example, we have the NJAC case from 2015, where the court again struck down a constitutional amendment that sought to change the appointments process for judges. So I wouldn't be surprised if a similar confrontation were to take place today, if the court would put its neck out and try and protect its position once again.
You agreed with what went down in Keshav Singh? And maybe we should rewind and offer our viewers a three-line explanation on the case. It's partly comical how this case came into being, and also very, very serious because it looks upon many of these issues that Chintan has spoken about. It started with one parliamentary, MLA, right? He was Keshav Singh in Uttar Pradesh.
He was a worker, actually. Yes.
Right. Sorry, go ahead.
So it starts off with a worker in Gorakhpur in Uttar Pradesh, who essentially distributes a defamatory pamphlet about his local MLA. And he is hauled up for breach of privilege. He initially refuses to enter an appearance in Parliament. There's an escalation, if you like, of events. And it reaches a situation where the Assembly asks this individual to requests his imprisonment. He's imprisoned for a period of 6 days. Inexplicably, on the final day, he files a petition. 1 day before his sentence is about to be completed, he files a petition claiming that he could not be imprisoned in this way. The matter then goes to the Allahabad High Court. The Allahabad High Court takes it up. In the meantime, the Assembly itself is now offended that the Allahabad High Court has taken up the matter. And the Assembly seeks to haul up not only Keshav Singh, the individual himself, but both of the High Court judges that heard the case. as well as Keshav Singh's lawyer. That's the matter that's ultimately referred to the Supreme Court as a matter of precedential reference.
And the Supreme Court had to decide whether the High Court had the right
Yes.
to intervene in a matter that was predominantly within the jurisdiction of the Assembly.
Correct.
And
Yes.
the Supreme Court, in just simple short words, ruled that the High Court did have the right.
Yes, that's right. That's right.
Okay. So you're saying if it were to play out today,
Yes.
that the court would probably rule exactly the same way. Do you agree with what went on?
I think that the court would rule in much the same way. And I think in principle, the court's decision was right. I don't have any objection to the court's decision in principle. My only trouble with the court's decision is that just before the Keshav Singh case, the court had ruled. Now, there's the issue of what the relationship is between fundamental rights, such as the right to life, the freedom of speech, and so on, and parliamentary privilege. In the event of a conflict between a fundamental right and parliamentary privilege, which one prevails? And the court in two decisions, so in the Keshav Singh case and a previous case called the Searchlight case, arrived at contradictory conclusions.
Yes.
So in one case, the court says, no, well, the fundamental right prevails. In the other, it says, well, no, parliamentary privilege prevails. Now, the difficulty is that that's resulted in a huge amount of ambiguity. And the only conclusion that you can draw from this is that, well, parliamentary privilege probably prevails over some fundamental rights, but not others. The trouble with this scenario is that this has resulted in Parliament not enacting its privileges into law. And so what was envisaged at the time that the Constitution was enacted was that the initial set of privileges
Would get codified.
Into law by Parliament. And the initial set of privileges was pegged to the privileges in England, in the House of Commons in England, and that was just meant to be a transitional provision. Now, because of this group of judgments, including Keshav Singh, Parliament has had no incentive to codify the privileges. Because as soon as you codify the privileges, they become ordinary law and they become subject to fundamental rights. So why clearly make them subject to fundamental rights when you can benefit from some ambiguity?
And that position stands even today.
That position still stands.
Okay. As a citizen, why would this matter to me?
As a citizen, this matters because to what extent, the question you need to ask as a citizen is, to what extent can you criticize members of Parliament? Can you defame a member of Parliament? Can you libel a member of Parliament? And if you do so, what happens? Are you merely subject to the legal process, or are you also subject to a legislative process? Now, as we know, Keshav Singh was subject to a legislative process.
Right.
He was sent to prison by the Legislative Assembly. And it's hard to know in those situations how someone in Keshav Singh's position can put up a defense. So it's essential for a citizen in this situation to know ex ante what they can and cannot do and what kind of defense they can mount.
Especially in days that we live in, where Parliament is dominated by a particular political party majority.
Yes.
And that can work against those citizens that don't necessarily agree with that majority view. So, okay, I want to move on to the second one. Again, a big one in your book. This is the Minerva Mills case from 1973. If I may call it in layman terms, it's the saving the Constitution case.
Yes.
In some ways. So, why and how did Nani Palkhiwala win this case?
So, Nani Palkhiwala adopted a masterful litigation strategy.
You want to tell us a little bit about what the main case was about in a line or two?
So, what this case is about is that we have the Keshwanand Bharti case.
Correct.
That's the backdrop to the Minerva
That's the
Mills
basic
case.
structure case.
That's the basic structure case which we've talked about. Following the basic structure case, the Congress government makes amendments to the Constitution in order to undo the basic structure case.
Right.
So it makes amendments to the amending clause of the Constitution.
Essentially to say that Parliament can amend the Constitution as it pleases.
Yes.
And those amendments are not within the purview of Supreme Court review.
Absolutely.
Correct?
That's right.
Simple. Yeah.
That's
right. That's it.
Now, Nani Palkhiwala was representing a mill which was based out of Bangalore, which had been nationalized.
Right.
But what he does is, rather than challenging the right to property had also been deleted from the constitution.
Right. That was by the subsequent Janata Party government.
That was by the Janata government. Now, rather than challenging the right to property that had been deleted, he decides to use this case as a vehicle, as a conduit, in order to challenge the Congress government amendments.
Okay. Now, I just want to here's where I'll interrupt you a bit.
Yes.
I'm guessing he didn't, look, there's no way to read Nani's mind,
Yes.
but I'm guessing based on your study that he didn't take on this case just to fight against the nationalization of it. That maybe somewhere in his mind, these introductions by the Congress government, specifically Articles 368
Yes.
and 31C, these were things that he wanted to have overturned or at least attempt to do so, and so he used this route?
Yes.
Maybe that's one way of assuming this?
I would have thought so. I would have thought so. Of course, we don't have any clear evidence that there were ideological reasons.
Yeah.
But I think there is strong circumstantial evidence that there were ideological considerations, particularly because he had taken a position as an ambassador to the United States. And I quote an interview he gave to the New York Times in the book, where he talks about how he was looking forward to working with the US government and how he agreed with President Carter's philosophy and the like. And he ultimately resigns from that position, and one of the early cases he argues following that resignation is Minerva Mills.
And so in that, he wants to make the point that Parliament does not have the right to amend the Constitution as it pleases. This goes back to the Keshavananda Bharati case, doesn't it? So what does Nani Palkhiwala argue differently from the Keshavananda Bharati case that sort of helped save the Constitution? So
the basic principle postulated in the Keshavananda Bharati case is that Parliament has no right to abrogate, alter or destroy the basic structure of the Constitution.
The core of the Constitution.
Absolutely.
Yeah.
What Parliament now does is, intelligently you might say, is to amend the amending clause to say that, well, we can amend any part of the Constitution and the court does not have a right to review any part of the Constitution that we amend. So this is a clarification, if you like, of the amending clause of the Constitution. What Palkhiwala argues is that the limited amending power is itself a basic feature of the Constitution. And what he says is that the recipient of a limited amending power cannot use that very power to convert the power into an unlimited amending power, because that converts the creature of the Constitution into its master. So this is the argument that Palkhiwala quite intelligently uses.
Should the Constitution be open to wide-ranging amendments? In your view?
I'm skeptical about whether the Constitution should be open to significant amendments. I think there is room for a basic structure doctrine. There was certainly room for a basic structure doctrine in the political context of those times.
Right.
I think there still remains room for the basic structure doctrine today. But I should emphasize that I think its use should be restricted. And I think we should be careful about deploying it wantonly in all manner of case, where we're concerned about what the government is doing and the like. It should be deployed fairly narrowly, in my view.
How do you respond, Chintan, to arguments that a lot of people from civil society make today, saying that why should the Constitution as a living document not change, with the passing times or the passage of times, and that especially when a majority of the citizens, represented by their elected representatives in Parliament, are in favor of a particular change, then should the Constitution not bend to that?
I think the basic structure doctrine, at least the way I look at it, is perfectly consistent with that view. And it's consistent for the reason that what the basic structure seeks to protect is the identity of the Constitution, simply the fundamental identity of the Constitution. You can make significant amendments to a document without changing its identity. What you can't do is to change some of its features in a manner that changes the very identity and the character of the document itself. It's really only that radical nature of change that the basic structure doctrine seeks to prohibit. It doesn't seek to restrict the evolution of the Constitution based on changes within the country, so socio-economic changes and the like.
Okay, I'm going to come back to the Minerva Mill case because there are many interesting facets to this. Now, 2 judgments were delivered in that case.
Yes.
One by Justice Chandrachud, your grandfather, who delivered the majority decision that struck down both the contentious articles. And the second by Justice Bhagwati, also a renowned judge of his time, who wrote a separate opinion, and he agreed that 368 should go, but he didn't quite feel the same way about 331C,
Yes.
right? Now, here are 2-3 things I want to question you about. When Justice Chandrachud, came to this majority decision in the Minerva Mill case, it went against his view in the Keshavananda Bharti case. So in the Keshavananda Bharti case, when he was on that bench, he had in fact ruled against the basic structure doctrine. In this case, which is Minerva Mills, which comes after Keshavananda Bharti, he upholds the basic structure doctrine. How did you interpret that?
So the way I interpreted it is
an acknowledgement that he was wrong in the first place, or that whatever the Supreme Court had decided in majority was right?
I think both. I don't necessarily think he was compelled by judicial discipline to take the decision that he did. Because if he was, then that's not really an acknowledgement that he was wrong. That's merely an acknowledgement that he has no choice but to comply with the Keshavanand case.
Because majority decided that, basic structure prevails.
Exactly, because that was a 13-judge bench. This is a much smaller bench.
Correct.
A smaller bench is bound by a larger bench. I think if he wanted to, there were certainly opportunities and avenues available to depart from the basic structure case or to uphold the amendments to Article 368 on the basis of the amendments that had been made by the Congress government. And the reason for this is that many scholars argued at the time that the basic structure doctrine was in fact grounded in text. It was grounded in the language of the Constitution itself.
Okay.
Now, if you have an amendment to the text itself which clarifies what the amending power is, how can you say that it's grounded in the text? You might well say that the rationale for the basic structure doctrine had been dislodged. So there was an avenue available for him not to comply with Keshavanand.
And why did he not take it?
I think because my view at least is that he probably acknowledged that his own view in Keshavanand was wrong.
Now, this view you've arrived at through a study of the judgment objectively, or is it something that you know through, let's say, passage in the family generations, so to speak?
So this is purely on a study of the judgment. I've never had an opportunity.
I had to clarify this. Right?
I've never had an opportunity to discuss Minerva Mills with him. I wish I had, but this is based on a view,
But did you ever have, I will come back to this point later,
Sure.
but did you ever have a chance to talk to him about Keshavananda Bharti?
I don't think so. Very, very briefly, but my memories of that are rather faint. And so all of the analysis and the conclusions that I've drawn in this book are based on materials which are accessible to the public at large and not just to me.
Fair point. All right. Interestingly, in this case also, as I pointed out, Justice Bhagwati, also he wrote a separate opinion. He agreed that 368 should be struck down, but not Article 31C, saying that fundamental rights had no meaning, if directive principles were not upheld, so to speak. And I'm putting all of this in simple layman language. But more interestingly, you speak of a dispute of sorts between the 2 judges, right?
Yes.
Justice Bhagwati and Justice Chandrachud.
Yes.
Give us just a glimpse of it. I've read it, so I know what it is.
Sure.
But I found it to be a fascinating part of this story. So.
Sure. So the background to this is, and of course part of this is based on conjecture, but the background to this is that Justice Bhagwati is appointed to the High Court before Justice Chandrachud, but Justice Chandrachud gets elevated to the Supreme Court before Justice Bhagwati, resulting in a long tenure of Chief Justiceship for Justice Chandrachud and a much shorter tenure of Chief Justiceship for Justice Bhagwati. This is the broader context. And when you look at the Minerva Mills judgment in that context, you notice some disagreement between the justices on several points, which you might well say gets to personal disagreement as well. And so one example of this is that in his upholding of Article 31C, Justice Bhagwati quotes a provision from Justice Chandrachud's own judgment in the Keshavanand case. Justice Bhagwati also in the Minerva Mills case complains about the fact that there was no judicial conference, there was no opportunity for a meeting of minds.
Basically,
between
the 2 judges, or all the judges on that bench in
Yes.
Minerva Mills, did not discuss the decision before articulating it in an order.
Exactly.
Right? That's his complaint.
That's his complaint in Minerva Mills.
Yeah. Which is also similar to the complaint that Justice Chandrachud had made in part in the Keshavananda Bharti case.
Correct.
Where he had in the Keshavananda Bharti case brought up the fact that there was not enough judicial consultation before the two decisions were arrived at.
Exactly. So you see Justice Bhagwati drawing upon much of what Justice Chandrachud has said in the Keshavanand case.
And using it against him.
Using it against Justice Chandrachud.
Yeah. So why did you wade into this? I want to know. Because I found it super interesting, and I also wondered whether you were nervous when you were writing this, because you have to be objective as an author.
Yes.
You're dealing with two very renowned judges, one of who was the Chief Justice, and who's also your grandfather.
Yeah. I waded into this because I found this far too interesting not to include in the book.
Sure.
It formed part of the socio-political dynamics at the time. And in addition, it had an interesting practical implication, which is that the government tries to review Minerva Mills. And one of the significant arguments that the government uses is in fact Justice Bhagwati's point, that there was no judicial consultation. And so therefore the government says that this is not a view of the bench, but these are views of individual justices. I don't think that's an especially persuasive argument to make, but that's the argument that the government does in fact make.
That review failed, right?
Exactly, that review failed. That review never really went through beyond an initial hearing that takes place before the 5 justices.
Okay, great. Just super. If you're even partly confused by what we've just said about Justice Chandrachud and Justice Bhagwati, I urge you, if not to read the full book, at least to read that story. It's a treasure trove, Minerva Mills, and I'm so glad I had the opportunity to read it, both from the point of view of how different judges have looked at this issue of basic structure, doctrine, and also some of the more personal angles that Chintan has brought out. I'm going to jump a few cases in the book, not talk each one about them individually, but in the case, the Durai Rajan case now I'm referring to, which is predominantly about reservations in education institutions, right? Reservations for the lower castes, to put it simply again. Now, in that, what I found most interesting is that you traced that case the beginning of the public interest litigation system, if I can call it, in India, right? In that case, Durai Rajan, who is, the complainant, she did not actually apply for admission into a college, but she filed this case representing the upper caste of Brahmins on a broader basis. So, is that you think the beginning or the origin of PILs in India?
So I wouldn't necessarily say that that's the very origin, but that provides amongst the earliest traces of PIL that you would find in the Supreme Court.
Okay.
Because you had this rather peculiar situation. Now this case involves 2 students, Srinivasan and Durai Rajan, and Srinivasan has actually applied for admission. And been told that he will not be securing admission on the basis of reservation.
There are not enough seats for him.
Correct. In circumstances where if there was no reservation, there would be a seat for him. Durai Rajan, on the other hand, is in this unique position where she decides not to apply at all, but speculatively files this petition saying that if she were to apply, that she would not secure admission because of this reservation policy. So what she is effectively doing is to represent not just herself, but her community, the community of Brahmins, claiming that the government order implementing reservation was unconstitutional.
This Durai Rajan case is the post-emergency court, isn't it?
So this Durai Rajan case is from the 50s. It's one of the early cases.
The early things. Okay.
Exactly.
So the reason why I ask this is, and I may be completely wrong because I'm not a scholar of this, but the increase in public interest litigation and the expansion of the scope of powers of the Supreme Court, especially after the emergency, Justice Bhagwati, was the flag bearer for many of these, seemed to me almost like an effort, a redemptive effort for the court. So I'm trying to link what happened in Durai Rajan, which was at a different time period altogether, to the growth and the escalation of PILs in India. And today now we have the problem of misuse of that route. To try and understand why the court has allowed for this to get so out of hand.
Right. So the dominant narrative is that you have just chronologically, you have the emergency taking place in 1975. Then you have the ADM Jabalpur decision in 1976, which most people say is the darkest hour in the Supreme Court's history. And thereafter, there's an effort, or so the dominant narrative goes. There's an effort by the Supreme Court to widen access in order to redeem itself, in order to enhance its reputation after the ADM Jabalpur judgment. But what's interesting is that in parallel with that effort, the court takes a number of decisions in which it doesn't in fact necessarily reflect itself in the best light.
Sure.
And I've covered many of those decisions in these cases, including the national security decisions, including decisions on gender and the like. That's where this PIL story begins. It does begin with the court taking up petitions from those who are genuinely in need. So it starts with the likes of bonded laborers and communities that are at the margins, if you like. It increases representation of those that don't have representation in the mainstream political process. I think what happens thereafter is that PIL transforms into this tool for a huge community, all manner of people, to access the court and file petitions claiming a large number of reliefs. And so therefore there's an increasing concern that PIL is being abused, misused, not necessarily being used in consonance with its original intentions.
As a journalist who covers court and legal matters, the one thing I struggle with the most is to try and understand this contradiction. That when it comes to protecting fundamental rights, the Supreme Court has not had a good record at all, right? A very checkered one, as we've already partly discussed so far. And yet it constantly seeks redemption by expanding the PIL route or by allowing for an expansion of its own jurisdiction through the PIL route. I'm not able to understand what court this is. I mean, why is it that the court can't do what it's mandated to do constitutionally, that it fails at, and then it keeps seeking redemption by either fixing a monkey problem in Delhi or trying to create a quasi-executive issue or solution around pollution, but doesn't really stand up when there is an internet ban in Jammu and Kashmir. I mean, I'm not able to understand this court. And so I'm wondering if you have had a better reading of this than I have.
So my reading of this situation is that when the court on the one hand, say, addresses the monkey problem in Delhi, its decision is clearly not a decision that is going to be politically controversial. It's not one of those that's a political hot potato. At best, what you might say is that it's a decision which politicians have refused to take or are quite happy to defer or to dump on the courts. On the other hand, when you have cases where rights genuinely need to be protected, those cases tend to be far more politically controversial, where the court will be concerned about the political implications of its decision, and I don't say this necessarily in a party political sense, where the court will be concerned about the consequences of failing to comply with its own decisions. And I think the other way of looking at this is that the majoritarian view is probably that the monkey problem is a problem and needs to be dealt with.
But the shutdown of all communication services in a state in this country is not a problem.
Exactly. That might well be the majoritarian view. And the difficulty is that the court inherently is expected to be a counter-majoritarian institution.
But it never does turn out to be that.
But often in the recent past, it's failed to live up to that reputation or that expectation.
Not just the recent past, going back 30, 40 years.
Absolutely.
Now, right? Okay. You trace the jurisprudence on personal law versus fundamental rights in the NARAS case. Now, before we move ahead, I want you to first outline the NARAS case in a couple of lines, and then I'll put my question to you about this conflict, long-standing one, between law, personal law and otherwise.
Sure. So the NARAS case involves a case where a number of people were prosecuted under a law that prohibited bigamy in Bombay.
Correct.
These are Hindus. The question that arises before the Bombay High Court, now this is the only High Court case that I've covered in the book. Every other case I've covered in the book is a Supreme Court judgment.
Culminates in the Supreme Court.
Exactly. The question that arises before the Bombay High Court is, to what extent are personal laws subject to the scrutiny of fundamental rights?
Right.
And when I say personal laws, I mean uncodified personal laws that have not been codified into any kind of statute.
So religion-led practices or community-led practices.
Exactly.
Right?
And these can arise from scriptures, the shastras and the like.
Right.
And the decision that the court reaches in that case is that personal laws will not be subject, uncodified personal laws will not be subject to the scrutiny of fundamental rights. And therefore they paradoxically are above and beyond fundamental rights and have a status that is higher than the status accorded to democratically elected or enacted legislation.
Okay. Now, how does this square with the fact that the Constitution has a provision for the enactment of a uniform civil code in India?
Now, the decision in NARAS was made in an interesting socio-political context. It was that the court was conscious of Article 44 of the Constitution, which charged the state with endeavoring to secure a uniform civil code for the citizens.
Right.
And so my reading of NARAS is that the judges, there were two famous judges, Justice Chagla and Justice Gajendra Gadkar, saw the NARAS case really as a case that would apply to a transitional period between the Constitution having been enacted and a uniform civil code coming into force. The judges probably didn't expect that judgment insulating personal law from the scrutiny of fundamental rights would continue in place for decades
Still does, right?
It still does. It still does.
Even today, religion-based or community-based personal laws rank over fundamental rights.
Yes. Uncodified personal laws rank above fundamental rights. Now, courts have been trying to find different ways of sidestepping NARAS without overturning it. And they do this in a number of ways. So one way in which they do it is to, for example, say that this is not personal law. In fact, this is not religious personal law. It's something else. It's just practice, and therefore it is subject to fundamental rights. Another thing they say is that, well, okay, does this fall within the essential religious practices or not? And if it isn't, then again you don't benefit from the protection of NARAS. So there are ways in which the court has attempted to sidestep it, both in the distant past and the recent past. But NARAS has never been decisively overturned.
Let me connect this to the present.
Yes.
We have a government that is keen and has articulated its desire to bring in place a uniform civil code, right? You have said in your book that even though the Constitution promised a UCC of sorts, and I use the word promise loosely, there was trepidation at that time that it would hurt India's plurality, which is why NARAS was supposed to be transitional, a UCC was supposed to come in place, but that never really did happen at any point in time. And the judges that were hopeful that the UCC would, in a sense, sort of overturn or put to rest the NARAS question, that question continues to hang over us.
Right.
Is it right time to consider a uniform civil code in India?
So the difficulty that I have with debating the uniform civil code is that it's often debated in rather abstract terms without considering what the terms of the uniform civil code will be in particular.
So you need to see the fine print before you decide. That's what you're saying?
Absolutely. That's what I'm saying.
Okay.
I don't necessarily think that the uniform civil code is a bad idea in principle. But the concern that many would have is that the uniform civil code would essentially be used as a euphemism for a code that governs one community or that draws from the laws that apply to one community and seeks to apply it to everyone else. Now, if it's implemented in that way, then you might well say that that's not the UCC that was intended by the Constitution, or that's not a UCC that's desirable for India. On the other hand, if you have a UCC that draws from a number of communities, that upholds rather than rejects the plural values of India, then you might well say that that's a good idea.
And you would find that the courts would be, because eventually, let me put it this way, it's such a contentious issue that even if a UCC were to be legislated and passed both houses of Parliament, there's a fairly good chance that someone would find a reason to challenge it, in the Constitutional Court. How do you think the courts would be able to measure whether the UCC actually does do justice to the plurality of India and doesn't necessarily only represent a particular religion, the majority religion or the major religion being Hinduism?
So the court will probably need to determine to what extent the UCC draws from the practices of different religions and the extent to which the UCC respects different religions and different ideologies. If it does that, and this will be tested based on, say, the right to equality, the right to religious freedom, and the like. If it does that, the court might, may well uphold the UCC. If it doesn't, I wouldn't be surprised if the court will apply a greater amount of scrutiny to consider whether it's constitutionally
I'm not trying to prejudge this.
Sure,
I'm just trying to understand the framework within which all of us should be prepared to understand an event of this nature, because it does seem that it will come in the next 3 years at some point, and so therefore to be prepared with the kind of a macro framework that sort of puts this in the right context is important.
Sure, and the other point to add is that any government that enacts a UCC will undoubtedly rely on Article 44 itself to say, well, you shouldn't really be challenging this because we've complied with the directive principle of Article 44. But the debates will probably be over, number one, is this a uniform civil code at all?
Uniform being the key word.
Uniform being the key word, or is this doing something else? Two, even if it is this the kind of uniform civil code that was envisaged by Article 44? Or is this just a pretext to do something else? So I think that's probably where the debate may well start once, if and when the UCC is enacted.
Well, I don't think if is in question, but when definitely is in question, right, at this point. The last portion of your book is devoted to national security cases, right? There are many landmark ones in them. You've already articulated some, some of the interesting points in the Tata case, so to speak. I won't pick case by case. What I do want to ask you is again a broad question that probably you've already answered so far as we've discussed the role of the Supreme Court in this country, which is the Supreme Court's squeamishness when it comes to being able to weigh accurately or correctly national security concerns versus fundamental rights, right? I go back to the issue that I just brought up to you, and I'm using a contemporary issue at this point, which is the, let's say, communication ban in Jammu and Kashmir. Now, it's one thing that the court rules in favor of national security. It's another thing that the court has refused to even hear the case for weeks on end. It refused to even, just a few months ago, it refused to even hear habeas corpus cases emerging out of Jammu and Kashmir or the situation there for weeks on end. So, you've explained that the court finds it easier to sidestep controversial issues or stay where the majoritarian view is. What explains this almost cowardly behavior, if I may call it, that the court has refused to even listen to the cases in good time?
It's difficult to say. What I'd say is two things. A reticence in dealing with national security cases robustly is not unique to India. You see this in several jurisdictions. The second thing I'd say is that some of it might well be attributed to the law of unintended consequences, rightly or wrongly. So, for instance, in this case, the court may have been concerned about what the impact of its decision would be if it decided to lift the communications blockade. Now, remember, one of the issues that arises in this case, quite remarkably in my view, is that the government plays fast and loose with the Supreme Court as to what form of communication blockade is in place in which parts of the state. In fact, at one point, the government almost seems to suggest that it itself is not very clear on what forms of communication are blocked, where, for what period, and the like. One thing that a robust court could well have done is to say that your starting point, the default rule is that all communication is open. And it's only from that starting point that you then can justify closing communications in one region or another. And if the government is unable to explain or unable to justify what communication blockades are in place, where and when, then the blockade must be lifted entirely and the government needs to start afresh. Now, the court may have been worried about doing this because, again, it wouldn't have known what the impact or the implication of that sort of decision would be, whether it would result in unrest, violence, and the like. Again, I don't necessarily think that that's a good justification for what the court has done. In my view, a judgment that is a 130-page judgment that seeks to pronounce on the constitutionality of a communications blockade must in fact pronounce on its constitutionality rather than merely laying down important, lofty principles.
Yeah, well, you're judging the judgment.
Yes.
I'm saying for weeks they didn't even consider hearing the cases.
Yes.
I was most astonished.
Yes.
You can fault the courts for picking one view or another,
Right.
for picking a view against what the government has done, the
Yes.
government of whichever day, or standing with the government and saying no, maybe this is justified from the national security point of view. But what I simply cannot find any justification for is the incredible delay that the court allowed to take place before even giving these cases the right hearing.
Yes.
Many of these cases are still pending in court, if I may say so, and have been pushed to various dates in February, etc., which is several months after the J&K issue came up. And I'm just using the Kashmir issue as an illustration for how the courts have often run away from having to deal with any of these issues. Right?
In this instance, as it happens, I'm less concerned. I do agree with you to an extent that the delay is inordinate. So if you were to look at the period between the lockdown, which is the 4th of August, to the court's judgment, which is the 10th of January, you have about 5 months. Now, I think 5 months is slightly long, but that's not what concerns me most about the court's judgment. In fact, I would have been rather happy had the court decided to rule robustly and taken an extra month if it wanted to. So one thing that the court does is it refuses to force the government to produce all of these orders imposing the communications lockdown, and simply passes the buck back to the government and says, these are the principles, go ahead and apply them and we'll see what happens going forward. I wouldn't have minded, for example, if the court took an extra month, asked for all of those orders, and then made a final and decisive decision in respect of those orders. Due process does take time, but what matters for me is not necessarily the length of time, but the impact of the court's decision itself. And what disappointed me here was the ultimate product, the ultimate decision.
Okay, so we have two disappointments, yours and mine in this case. You've looked at how the Supreme Court has dealt with fundamental rights, national security, and all of these conflicting issues, over the last several decades now, as you've profiled these stories in your book. Every generation feels as if, my God, this decline in the Supreme Court, this decline in the judiciary, its inability to respond to issues of our time, it's the worst that it ever has been.
Right.
But it's actually been quite constant over the last 4 or 5 decades at least, right?
It has. I think it's been constant. I think the one difference that you can articulate between, say, now and 4 decades ago is simply volume. The Supreme Court now deals with much, much more than it dealt with 50 years ago or even 25 years ago. And of course, the Supreme Court of the 50s is an 8-member court. The Supreme Court of 2020 is a 34-member court. And the reason for which this is important is that when you deal with large volumes, you also need to think about priorities. When you deal with large volumes, what that necessarily implies is that some cases are more important than others. And the pecking order with which you decide these cases now becomes especially significant. And my concern is that the court is increasingly using the tactic. I use using in a colloquial sense. I don't mean it necessarily very cynically. But the court is increasingly using this tactic of judicial avoidance, which is to refuse to consider significant cases, matters of constitutional importance, until you get to a situation which is irremediable. And if you want an example of this, just look at the electoral bond scheme case.
Absolutely.
Where there is a credible challenge. I won't comment on whether the challenge is correct or not correct, but I'd say there's a credible challenge to the government's electoral bond scheme. And several elections have now passed and the court has not made its decision. It's nowhere near making its decision. Now, how do you deal with the impact that scheme has had on all of the elections since that scheme has come into place? And you'd of course draw a blank.
There's
nothing you can do.
That's lost. There's nothing you can do.
And
so the only question, the answer to which I would like to determine, is whether the court has simply delayed the hearing of this matter and arriving at a decision because it's burdened with too many other matters, all jostling similarly in importance, or the court is running away from deciding some of these things.
I would probably give the court the benefit of the doubt and say that it's it's burdened with far too much. But where I wouldn't give it the benefit of the doubt is on prioritization. It needs to think very carefully about rostering which cases need to be considered with alacrity and which cases, monkeys in Delhi, just as a hint,
Yes.
can be considered later in the day.
Well, part of the problem then is self-created, because PILs is a self-created jurisdiction, and monkeys in Delhi should never have become the Supreme Court's problem, but it has.
Yeah.
And so, important issues like electoral bonds then get pushed to the back burner. All right,
Absolutely.
final question. You come from a family of judges.
Yeah.
So it was curious. In this book, you've reflected on the decisions made by your grandfather. We discussed the Minerva case. You've reflected on a decision made by your father, the Sabrimala case. What was it like to be able to look at their judgments objectively, having obviously grown up in the same house?
So I tried my best to look at their judgments taking with an arm's length distance and to be detached when viewing their judgments. I've to some extent commented on and criticized some of my grandfather's judgments as well. And so one thing I describe in the book is that following the Mathura case, where the Supreme Court made an egregiously wrong decision, a bad decision, a group of academics wrote to my grandfather, who was Chief Justice at the time, asking him to review the decision. And he didn't do so. So I've tried to take a step back and not reflect upon dinner table conversations with the family and the like while writing this book.
They didn't seep into your consciousness as you were writing this?
I tried not to let them seep
To
to
be
the
fair,
extent
your father
possible.
has
Yeah.
overturned a decision or two of your grandfather's.
Yes, yes.
So, I won't get into the specifics of all of
Sure.
this, because this is not done on a personal basis. It's
Yeah.
done on a judicial understanding basis.
Yes.
So, but I was just curious what it's been like to grow up in a family of two very renowned judges.
It's been very inspiring, of course.
Of course. Now, that's the politically correct line.
Well, no, it has genuinely been quite inspiring. But I think the one thing that I've learned from many of those conversations and interactions is to hold the same values without necessarily being bound by the same views. And therefore, I'm entitled to, and I will take independent views, so long as I conform with the same broader underlying values and culture.
I'm sure you get asked this cliched question all the time, but you intend to return to India. Chintan is currently a lawyer with a London-based firm,
Yes,
right?
yes.
Do you intend to return to India and pursue the same career path or professional path as your father and grandfather did?
I'm not one of those that makes 5-year plans.
Are you going to become a judge? Will you be the third generation in judges in this family?
As of now, I'm happy in London. I intend to be there for the short term, and thereafter, who knows, we'll see.
Chintan, thank you for a wonderfully engaging book. I hope you do a second edition of this sometime soon enough, with more cases that you can bring to light. And thank you very much for this candid conversation.
Not at all. Thank you.
And thank you very much for watching BloombergQuint.